question that we always get about estate planning is, who should I designate as an executor, and what if I have two children? Can there be co-executors? One of the first things that you should think about when you designate an executor is who you want to wrap up your affairs. Who has the knowledge of the different assets that you have, also maybe some debts or liabilities that you have, and who knows where a copy of your will is. If this is your spouse or significant other, that's a great person to designate as an executor. The other person would be your children. If you don't have any spouses or significant others, then your children are a great alternate to executor. In terms of should we have one executor or two executor, it's always been our advice that we have one executor. Co-executors, in my opinion, often convolute and bog down the probate process, because in general, whenever an estate is filed with the probate court, the executor has to identify the assets and liabilities. The executor has to approve the different forms, sign the forms, and make sure that those forms get filed with the court. When we have multiple executors, that means multiple people have to approve the forms, file the forms, and make sure that they get signed and filed with the court. So this just bogs down the process. If you do have multiple children and you're concerned that one child may or may not hide assets, then when the inventory and appraisal gets filed with the court, the other child or other spouse or other heir gets an opportunity to review the inventory and appraisal and either approve it or object to it based on their knowledge. So in my opinion, that protects against some sort of collusion or some sort of concealment of the assets. If you have any other estate planning questions, feel free to give us a call at 740-346-2899.